Mr. Chair, and thank you very much. It is a privilege to take a call on the committee stage of the Judicature Modernisation Bill, sir. And I hope my contribution is a lot more clearer than me just pronouncing the name. Sir, Labour does support this bill, but I want to focus particularly on Part 1, Sub-Part 5, the Senior Court Judges, sir. And of course, I'm going to reference the submissions by both the Bar Association and the New Zealand Law Society, because who better to take a lead from this particular section of the bill but actual practitioners in this field, sir. And clause 93, sir, where it talks about the appointment or judicial appointment process, and the minister that was in the chair previously gave the outline around the flexibility and to avoid any overly prescriptive criteria when appointing judges. But I do want to, sir, draw the House's attention to the submission, like I said previously, to the Bar Association and the New Zealand Law Society when it comes to the judicial appointments, as noted in clause 93. And the comments that I draw from the submission, sir, particularly from the Bar Association, is the role of the Attorney General in appointing judges. And in their submission, sir, they are recommending that the appointment process that the Attorney General undertakes should be done in a consultative manner. And they've given a whole list, by way of example, sir, of the organisations or the actual individuals that they consider that the Attorney General should consult with. For example, the head of the bench of the court, the Solicitor General, the President of the New Zealand Law Society, the President of the New Zealand Bar Association, and such other people as he or she considers appropriate. So clearly, sir, the Bar Association remains and asserts that the Attorney General should be required by legislation to consult with specific people in advising the Governor-General on judicial appointments. And then when I turn, sir, to the report of the Ministry of Justice to the Justice and Electoral Committee, and I read this particular point I'm raising, clause 93, they make mention that there were a number of submitters that support that the Attorney General take a more consultative process in terms of making his decision. And then they talked about the Law Society, the Bar Association, the Human Rights Commission. And then they go through, as officials do, sir, to actually put up the argument on whether those recommendations should be taken or not. And I do note, and perhaps the Minister can explain to the House, that one of the reasons why they don't consider that they should take up the suggestion of a consultative process has to do with, and I quote here, sir, "We are not convinced that legislating set criteria and consultees is the only way to achieve this aim. In large part, the sunlight effect of requiring the process to be published are therefore open to public scrutiny." And I guess I would appreciate the Minister and the Chair just explaining that not taking the consultative process, sir, actually will ensure that we have an open and transparent part as per clause 93, sir. The other clauses I want to go to, and there's quite a bit in obviously subpart 5 of part 1, sir, but definitely to hear back from the Minister in relation to that point. The other one is obviously the criteria that's laid out in terms of the sort of qualities we want in judges when Attorney General makes the determination. And again, the Bar Association lays out, I think, sir, in their submission, a set of criteria that's quite clear in terms of suggesting statutory criteria, namely the personal qualities, including integrity, sound judgment and objectivity. Obviously, legal ability is one of those criteria that we should list. Mr. Chair? Mr. Chair? Mr. Chair?
I'm going to call out to Cinderella.
Mr. Chair?
Mr. Chair.